problem is you were given a chance at outpatient treatment and you didn't take advantage of it. If there's an issue, if there's something you have a problem with, if you feel probation isn't addressing it, you can always come to the court and say, Judge, this is not what they're addressing. Judge, I have a drug problem. Can you help me with that? Calling 2020 CR 2272, State of Texas versus Megan Hayes Wilhite. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Kelly Piddle.
And are you Megan Wilhite?
Yes, ma'am.
Am I pronouncing your last name correctly?
Yes, ma'am. Wilhite.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did
Yes,
you
ma'am.
understand them?
Yes, ma'am.
Are you the same Megan Hayes Wilhite who was placed on community supervision in 2020 CR 2272 for the offense of burglary of a habitation force on August 29, 2022 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, did then and there fail to report to the supervision officer as directed for the months of April, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, miss.
And Judge, this is going to be on the first amended motion to revoke. It's violated condition number 1 on or about the 26th day of September 2023 in Bexar County, Texas. The defendant, Megan Hayes Wilhite, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True, miss.
Your Honor, state waives all the violations.
Any objection?
No.
All right. Did you understand by pleading true to violations 4 and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison? Did you understand that? And up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, ma'am.
Court will find violations 4 and 1 true. Is there a proposed agreement?
No, Your Honor, we were going to go open to the court. The state was going to recommend 6 years TDC.
All right. So the state is asking for 6 years. Defense?
Judge, I don't know if she was just sworn. Can I have my client testify briefly?
Yes. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand if you'll state your name for the record.
Megan Hayes Wilhite.
All right.
Megan.
Just one moment. There's Rattling. All right. Who are these people? Are they on the docket? The only people who are allowed in the courtroom are defendants. Sorry about that.
It's okay, miss.
Megan, you understand the state is recommending that you go to prison,
Yes, sir.
and you're asking the court to send you to safety.
Yes.
Why?
I want the opportunity. I haven't been able to get any kind of help when it came to drug rehab, and I really do want the opportunity to be able to get clean. I think it's about time that I do something good with my life, and I believe that safety would be a reasonable option for me to be able to get clean and do the best I can for myself and my family.
What is your drug of choice?
Marijuana and methamphetamines.
Okay. When did you first start using marijuana?
When I was about 14, 15, and
When did you start using meth?
methamphetamines about 32 years old.
How old are you now?
38.
Have you ever received any type of outpatient or inpatient treatment?
No, sir.
In regards to the reporting, you didn't report for those months. Why?
I did not have a vehicle, and I had my belongings taken from me from an individual that I was living with. My phone, everything, all of my email addresses and everything had been changed up. I had no way to contact anybody. And I was just scared to go up to the probation office at that point. I already knew that I'd MTR'd, and I was just scared.
Okay. You understand that you could have gone up to probation at any time and they would have helped you and probably assisted you in getting your identification and that type of stuff, right?
Yes, sir.
Okay. But you didn't do that, right?
No, sir.
Okay. So you were placed on probation when? Like last year in August?
Yes, sir.
Okay. You didn't receive any type of treatment?
No, sir.
Okay. And so you're asking for it because you don't want to use methamphetamine.
Most definitely not.
Passwords.
State, any questions?
Just a couple, Your Honor. Ms. Wilhite, you did have an opportunity to review the court summary, is that correct?
Yes, sir.
And did you see here that this isn't your first MTR?
Yes, sir.
And isn't it true that at the last MTR, you were told to go to outpatient treatment and that was a part of one of the conditions?
Yes, sir.
and you didn't go.
I don't think that the outpatient was available at that time. They had told me that I was taking classes, but that wasn't. I guess in the, how would I explain this? They had me doing certain things at a certain time, and the outpatient wasn't at that time that I was going. I was going to classes downtown, but it wasn't treatment at that time.
Pass the witness, Judge.
No further questions.
I have a question. What classes are you saying you were going to downtown?
I was going to the theft classes.
All right. So what are you saying happened with outpatient treatment?
I hadn't gone to the outpatient treatment yet.
All right. Why not?
I had been working and I didn't have time to do it at that time. I hadn't been able to make time yet.
All right. So this is what I'm trying to get to. One, was outpatient treatment ordered for you? Yes or no?
Yes, ma'am.
All right. Did you do outpatient treatment? Yes or no?
No, ma'am.
What is your reason for not doing outpatient treatment?
I was, like I said, I was working at the time. I didn't have the time at that period of time. I was going to be making time for it, but I did not have the time at that period of time.
All right. Because, and the reason why I asked that question, because, and if I'm wrong, everybody can let me know I'm wrong. I'm going to take that as a sign of disrespect. But it seems as though you were saying that outpatient treatment wasn't available when the state was questioning you. Did I hear that incorrectly?
No, ma'am. No, not that it wasn't available. It's whenever I was with Ms. Martha Reyna, we were setting everything up. She had me doing the classes at that time, and I hadn't been able to do the outpatient treatment yet. Not that it wasn't available, because it was part of my agreement, but it just she had me doing the classes. I was checking in and everything like that with her, doing my UAs and everything. I just hadn't done the classes yet for the outpatient treatment.
Okay. All right. Any other questions?
No, Judge.
No, Judge.
All right. Probation.
Yes, Your Honor.
What is probation requesting?
Your Honor, the recommendation on the court summary is if she is not revoked, then to send her to safe P. I would like to point out this is her second NTR. And as she stated, it looks like she may have maybe entered the theft classes, but they were never completed.
Okay.
So at least we don't have record that they were complete.
All right. Anything else from either side?
Just brief argument, Judge.
All right. Then I'll hear argument state. You are requesting 6 years.
Yes, Judge.
Is there anything you wish to add?
Judge, it's just she's been given plenty of opportunities to attend treatment. Even when answering the questions on treatment today, she didn't really give an answer other than she didn't have the time to do it. She's been given chance after chance. That's why the state's recommending time in TDC.
All right. Defense.
Judge, the purpose of probation is to rehabilitate individuals. I understand this is Ms. Wilhide's second MTR, but if she's given an opportunity in safety and she's able to no longer use methamphetamines in the future, then that's the win, that's the purpose. And if safety is successful, then she'll be able to complete the rest of her probation. If it's not successful, she'll be back here and you send her to 10 years TDC. So we're just asking for that opportunity to try to get her to treatment so she doesn't continue to use methamphetamines.
All right. Anything else from you, Ms. Wilhite?
No, miss.
All right. Ms. Wilhite. The problem is it appears that you have started things, but you have finished nothing. And the problem is you were given a chance at outpatient treatment and you didn't take advantage of it. I could understand if you did outpatient treatment and it wasn't working. And everyone who comes into this court who's on probation, no, I always say, if there's an issue, if there's something you have a problem with, if you feel probation isn't addressing it, you can always come to the court and say, Judge, this is not what they're addressing. Judge, I have a drug problem. Can you help me with that? Judge, I have mental health issues. Can you help me with that? We have an open door policy here. You can always come in and ask for that. But you haven't taken advantage of that. I'm going to grant the motion and revoke you. The state is asking for 6. Defense, what are you requesting?
Judge, we're asking for 4.
Okay. All right. I'll sentence you to 5 years in the prison. give you credit for any time served. Is there still restitution owed? Because there were several people
Yes, ma'am.
restitution was to be paid to.
Yes, ma'am.
So did they ever put in any amounts of restitution that were due?
Honor. No, ma'am.
All right, so they didn't put in any amounts, so I don't have any amounts, and if they want to do something with that later, they will have to take it up as a civil matter or somewhere else, but this court is not going to put it in the orders because I don't have anything. There's still to be no contact with the complainants that are previously listed. And let me write those down. If you would like, what I can do is I can recommend for you the therapeutic community. I am not in charge of whether or not they give you or place you in the program. You'll have to still request it, even though I put it on the form recommending it. It will not increase the length of time that you are in custody. So for example, if you're coming up for parole in 2 years or whatever, and you have not completed the therapeutic community portion of it, they're not going to say, well, we're going to give her parole, but since she hasn't completed the therapeutic community, we're going to keep her. That's not the way it works. It's just there for you while you're there. Would you like that?
Yes, ma'am.
All right. So I'll order therapeutic community. You're still going to have to ask for it, okay?
Yes, ma'am.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. And state has tendered dismissals and the misdemeanor cases that are pending. All right. Is there anything else?
No, ma'am.
That's it.
All right. Good luck to you. Okay.
Thank you.
Well, court is calling 2023 CR 7145, State of Texas versus Ricardo Tavares. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Now for the defense.
And are you Mr. Tavares?
Yes, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tavares, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 1, 3, and 4. We're proceeding on count 2 alone.
Any objection?
No objection.
Mr. Tavares, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count 2, you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That is a second-degree felony. Off the record for a moment. Probation, this is no application. And we're back on the record. The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Tavares, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Honor. Yes, Your Honor.
According to the plea, the state is proceeding on count 2. There are no applications, and they're asking that your punishment be assessed at 3 years in the prison. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, Your
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There were none, Judge.
Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State Exhibit number 1 with all the attachments.
We have no objection.
All right, state, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding to sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just ask to follow plea agreement.
All right, court will follow your agreement. The court will sentence you to 3 years in the prison, give you credit for any time served. Is there anything else with regards to sentencing?
Nothing further done.
All right, Mrs. Tavares, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
I'm 35.
All right, do you have any children?
Yes, I do.
All right, here's the thing. You know that life keeps getting short for people. I can say that I'm in the twilight of my life. You're going to have to make a decision on if you're going to change or if you're going to spend the rest of your remaining time on this earth in and out of jails, in and out of prisons. I'm sure your children would love for you to be clean and sober in their life. If there's a drug or alcohol problem, there are plenty of free places. If you would like, I could actually have you referred to the therapeutic community at the prison. It will not increase the length of time that you're in prison. So, for example, if they're going to parole you at 2 years, they're not going to say, we're not going to parole him because he's in the therapeutic community. It's just something to get you on the right track. Would you like that?
Yes, Your Honor.
All right. Caroline, can I see the following Tavares again? All right. Well, good luck to you. Okay.
Thank you.
All right.
The courtroom goes quiet as the case of Megan Hayes Wilhite is called, and the weight of what's about to happen is immediately clear. This isn't a routine check-in or a technical violation. She is standing before Judge Stephanie Boyd on a burglary of a habitation case, one of the most serious property crimes under Texas law. She has already admitted to violating her probation, not once, but multiple times. Failing to report to supervision and committing a brand new theft offense while still under court supervision. With those admissions on the record, the stakes are no longer theoretical. She is facing a possible 10-year prison sentence. The prosecution makes its position unmistakably clear. There will be no more patience, no more halfway measures. The state recommends a flat 6-year sentence in the Texas Department of Criminal Justice. No probation. No treatment detours. Just prison. It's a signal that, in the eyes of the state, this case has crossed the line from salvageable to exhausted. Through her attorney, Wilhite makes one last plea, not for freedom, but for treatment. She asks the court to consider sending her to the SAFP Drug Rehabilitation Facility, a program often viewed as a final off-ramp before incarceration. It's the defense's last card, framed as a chance for recovery instead of confinement. But Judge Boyd doesn't immediately respond. Instead, she does something far more revealing. She turns directly to the defendant and starts asking questions that cut past legal strategy and into personal responsibility. The first question is simple but devastating: why didn't you report? Wilhite offers a string of explanations. She didn't have transportation, her belongings were stolen, she was scared. Each reason spills out quickly, as if quantity might substitute for credibility. Judge Boyd listens, but she doesn't interrupt. Then she pivots to the issue that truly matters. Why did you ignore the court's order to attend outpatient treatment? The answer changes everything. Wilhite admits she didn't go because she was working and didn't have time. That single sentence seals her fate. In that moment, Judge Boyd sees the pattern clearly. This is no longer about hardship or bad luck. It's about priorities. The defendant didn't misunderstand the rules, she chose to ignore them. She chose work over compliance, convenience over obligation, and avoidance over accountability. Court orders are not suggestions, and Judge Boyd makes it clear that when someone decides which rules matter and which don't, they're deciding their own outcome. With calm precision, Judge Boyd dismantles the foundation of the defense's argument. Rehabilitation requires participation. Treatment requires commitment. And probation requires follow-through. She summarizes Wilhite's supervision history with a line that lands harder than any raised voice ever could. She started programs but finished nothing. Promises were made, opportunities were given, and every single one was left incomplete. At that point, the door to SAFP closes. The motion for treatment is denied. The court grants the state's request for incarceration. Megan Hayes Wilhite is sentenced to 5 years in the Texas Department of Criminal Justice. While Judge Boyd includes a recommendation for the therapeutic community program within the prison system, a final nod toward rehabilitation. The message is unmistakable. Treatment is no longer an alternative to consequences. It will now happen, if at all, behind prison walls. As the gavel comes down, the hearing ends not with chaos or drama, but with finality. This wasn't about one mistake or one bad decision. It was about a sustained refusal to follow through when given chance after chance. Judge Boyd's ruling serves as a blunt reminder of how probation actually works. It is not freedom, it is conditional trust. And once that trust is exhausted, the system stops negotiating. This case wasn't just a sentencing. It was a line draw.